I want to talk about mediation and its impact in civil litigation. Mediation is mandatory in certain cities in Ontario, Toronto, Windsor, and Ottawa, and mediation usually takes place fairly early in the litigation process, usually before examinations for discovery. There may be production of documents required by either party just to fully understand the nature of the case that the opponent is facing. And it is very successful in resolving cases. So mediation basically is a third-party neutral who meets with both parties in an effort to resolve the case. And there are different types of mediators. Some are evaluative. That means he or she will offer their opinion of the case. Others, perhaps not so much. So these mediators are fairly well known. Usually they're retired employment lawyers who are well experienced in the subject matter. If parties cannot agree to a mediator, there's a court system that appoints a mediator from a roster. Most parties will agree to use a private mediator that's not on the roster. The mediator's expenses are also an issue in the settlement. Most often, if the settlement is made, the employer, that is presuming there's money being paid, the employer will also pay the mediator's fees. The advantage of mediation, in fact, any settlement process, is that the parties can do things through mediation that they cannot necessarily achieve in court. That includes allocating the settlement funds to heads of damages made in good faith that are intended to be non-taxable. And again, the impact of, for example, allocating money to aggravated damages, where there's, again, a reasonable basis for it, is that it allows that payment to be made to the employee without tax withholding. The minutes may specify no T4 or T4A is produced, and it also avoids an EI clawback on those funds. Also, the parties at mediation may agree to the terms of a reference letter that the company will give to the employee. Now, that's something obviously that cannot be obtained in court, so the mediation basically allows a wide range of terms of settlement that are relevant to the parties that often is not something you can get through the litigation process. So it's very important when you go to mediation to be open-minded. Don't go in with any predetermined, I have to get this amount of money or this has to happen. You should keep an open mind and let your legal counsel assist you if you're represented, and hopefully you'll get a good result. Usually settlement funds are payable within 2 weeks or so of the date of mediation. You should specify that's an important term, a fundamental term, so if it's violated, you have a remedy. And again, keep in mind the contents of the prior video, that if there is something that's contained in the minutes that represents a confidentiality covenant or some other statement that you can or cannot make or must make sure to comply with the terms of settlement, because a failure to do so may result in the entire settlement being voided and you having to repay any money received. So be cautious.